Hello students, welcome to all of you Shiksha 360. This is basically JAP classes by the Mukesh sir, and today basically we have to discuss chapter number 13 part 1 clear, and today basically we have to discuss chapter number 13 part 1 clear. So for all session basically for PPB accounts or legal you can join our sessions. Eh, Along with the theory clear, basically we will provide you the MCQs, numericals clear as per the requirement of the topic clear, as per the requirement of the topic clear. So let's start our discussion. Chapter number 13 part 1 banker special relationship clear. This chapter basically we have to cover in two parts. This is the part 1. In the next part basically we will cover this chapter along with the discussion of some MCQs clear, along with the discussion of some MCQs. In the examination basically you will find straightforward questions clear. Basically in the examination basically you will find straightforward question, not that much typical. But one thing basically I have to tell you that basically you have to go through the topics properly clear, or line by line clear. You have to cover everything clear. You can easily score 60 plus marks in these subjects clear. So let's start our discussion. Banker special relationship clear. In the previous session basically in the previous chapter, that is banker customer relationship clear, that is basically here that is special relationship clear. So what is the meaning here special? So let's discuss now regarding that. So normally the account of the customer clear, normally the account of a customer with the banker is operated by the customer himself clear. Normally we can say that basically if there are 100 accounts in the branch, 95 or 96 accounts clear, 95 96 accounts clear are to be operated by the account holder himself clear. In some cases clear, basically there are occasions when the account holder gives an authority basically to the another person clear. Basically there are occasions basically when the account holder gives an authority basically to the another person, taking some legal documents to operate the account clear. Basically taking some legal documents basically to operate the account on his behalf clear. Clear. So there are occasions basically when the account holder basically gives an authority to the another person, taking some legal documents to operate the account on his behalf. Like we can say that like power of attorney. So in such a case, a special relationship basically it is created between the banker and the customer. Clear? In such a case, basically a special relationship basically it is being created basically between the banker and the customer. Clear? Between the banker and the customer. Now basically we have to discuss on detail all these special relations. Clear? Further, the obligation of a banker basically to honor a check drawn on the customer account clear, basically is subject to the condition that the money lying in the account is properly applicable for making payment clear, is properly applicable basically for making payment clear. There are also cases clear, basically there are also cases where a banker is justified clear, basically where a banker is justified in refusing payment to offer check clear. Like we can say that if check is not properly filled clear, or if the sign is not matched clear, or basically date is outdated clear, post dated clear. So all these things basically are to be meted clear, all these things are to be properly checked before doing the payment clear. All these things are to be checked properly before giving the payment clear, before giving the payment clear. So there are cases basically where a banker is justified in refusing payment of a check clear. So now let's discuss all these things one by one in detail. So first thing basically which we have to discuss here, that is the mandate clear, that is the mandate. So definition, that is basically a person competent clear, basically a person competent to enter into a contract may authorize another person clear. A person basically competent to enter in a contract basically may authorize another person to open and operate the account on his behalf clear. A person basically competent to enter into a contract may authorize basically another person to open and operate an account on his behalf. This authority basically can be granted by a mandate or a power of attorney. Okay? Like we can say that Ram went to Dubai. So in the meanwhile, basically Ram gives an authority basically to the Hina wife to operate the account, clear, to operate his account. So how they can give a, or how Hina can operate his her husband account, that is Ram, basically either by a mandate or by a power of attorney. Clear? So this authority basically can be granted by a mandate or a power of attorney. Clear? So now let's discuss in detail what is the meaning of that. So a mandate basically it is an authority. Clear? Basically a mandate basically it is an authority given by the account holder. Clear? A mandate basically it is an authority basically given by the account holder in favor of a third person. Clear? A mandate basically it is an authority basically given by the account holder in favor of a third person to do certain acts on his behalf. Clear? Basically a mandate basically it is an mandate, it is an authority basically given by the account holder in favor of a third person to do certain acts on his behalf. Clear? So basically this is issued by an account holder with the direction. Clear? This is issued basically by an account holder basically with the direction to his or her bankers, basically authorizing the persons to operate the account on his behalf. Clear? So basically this is issued by an account holder basically with the direction to his or her bankers, authorizing the person basically to operate the account on his behalf. Clear? To operate the account on his behalf. Clear? So the following are the salient points of a mandate. Clear? So the following are the salient points or the important points. Clear? Basically which we go through. Clear? Basically like the following are the salient points of a mandate. First one is the customer informing the bank. Clear? Here the customer basically informing the bank that he has authorized a person or mandatory basically to operate the account on his behalf. Clear? First one is the customer has to authorize. Clear? Or the customer inform. Clear? The customer basically informing the bank that he has authorized a person. Clear? The customer here basically informing the bank that he has authorized a person to operate the account on his behalf. Clear? That he has authorized a person mandatory basically to operate the account on his behalf. Second one, the signatures of the mandatory. Clear? The signatures of the mandatory basically are obtained in the mandate letter and are verified by the customer. Clear? And are verified by the customer. Clear? So this is like basically we can say that basically a person gives a mandate that this person basically doing dealing on behalf of me in the bank. Clear? On behalf of me basically in the bank. Clear? So basically they have to given a mandate in the bank regarding that. So this thing basically they are saying here that is basically the signature of the mandatory basically are obtained in the mandate letter and are verified by the customer. Clear? And are verified by the customer. Clear? Very, very important. The mandate is basically normally issued for a short and temporary period. Clear? The mandate basically it is generally issued basically for a short and temporary period. Clear? For a short and temporary period. Clear? So please remember these things. The mandate is basically issued basically for a short and temporary period. Next one, basically a mandate is not acceptable. Clear? Basically a mandate is not acceptable basically from the institutions. Clear? Basically it is mainly we can say that basically from the individuals. Clear? So basically from the institution, basically what we can do, that is power of attorney. Clear? That is power of attorney. Clear? So a mandate is not acceptable basically from the institutions. Institutions basically can issue a power of attorney. Clear? Basically they can issue a power of attorney. Clear? So in the case of joint account holders, clear? Basically if in the case of joint account holders, so all the customers or all the holders of that account, clear? Basically all the holders of that account, all customers must sign the mandate irrespective of operational instructions. Clear? Basically in the case of joint account holder, basically all customers basically must sign the mandate basically irrespective of operational instructions. While in the case of a partnership firm, clear? Basically while in the case of a partnership firm, all partners basically should sign the mandate letter. Clear? So it depends upon case to case. Clear? It depends upon case to case. Like in some accounts, clear? Basically you are also giving the power of attorney. Clear? Basically you are also giving the power of attorney. Clear? Mandate it is basically just for a specific purpose. Clear? Mandate it is basically for a specific purpose, like in the individual account. Clear? If a person is not able to come to the bank, clear? Basically for the checkbook. Clear? So basically they can give a mandate that on my behalf, clear? Checkbook is issued to this person and I am authorizing basically this person to sign on my behalf. Clear? So like this in this way. Clear? Generally basically if any person is going to the foreign, clear? So basically they give the power of attorney. Clear? That is basically this person is dealing completely on behalf of me. Clear? These are the things basically which you have to control. Clear? Or basically which you have to know. Clear? So in the case of the joint account holder, basically all customer basically must sign the mandate irrespective of the operational instructions. And while in the case of a partnership firm, basically all partners basically should sign the letter or should sign the mandate letter. Okay? And next, a mandate ceases basically to be valid on death. Clear? Stops. Clear? If the account holder insolvent, basically where it stops. Clear? A mandate basically ceases to be valid on death, insanity, insolvency, and bankruptcy of the account holder. Clear? And bankruptcy of the account holder. Clear? Next one, basically a mandate can be withdrawn anytime by the account holder. Clear? Basically a mandate can be withdrawn basically anytime by the account holder. Clear? In some cases, clear, basically if the account holder find that, clear, the person basically whom he authorizing, clear, basically for doing the transaction, basically they are doing some unauthorized, basically we can say that unethical transaction, or basically that is basically not basically with their approval. Clear? So at that time, basically we can say that basically a mandate, clear, mandate can also be withdrawn anytime. Clear? Basically mandate can also be withdrawn basically anytime by the account holder. Clear? Basically may be withdrawn basically by the anytime basically by the account holder himself. Clear? Or herself. Clear? So these are the things basically which you have to go through properly, or please remember all these points. Very, very important basically for the examination point of view for solving the questions. Clear? That is basically regarding the mandate. Please tell fast if you have any doubt, any query regarding the mandate. Okay, so now move to the next point. That is power of attorney. Clear? That is power of attorney. Clear? Definitely, basically, you will get basically one question from these things. Clear? And the question basically directly straightforward question. Just you have to remember all these things. Clear? The question basically straightforward question. Clear? Not like we can say that basically very much twisted question, but just you have to go through the theory very well. Clear? Or practice that points. Nothing extra basically they will ask in the examination. Just you have to go through that things properly. So next one here, that is next point basically which we have to discuss here, that is the power of attorney. Clear? Basically that is the power of attorney. Clear? Power of attorney basically it is further of the two parts types. That is basically general or universal, and special or limited. Clear? And special or limited. Clear? So basically it is a document executed by one person. Clear? Basically it is a document basically executed by one person. Clear? Basically who is executing that document? That is basically known as the donor. Clear? Or basically we can say that basically this person giving an authority to the another person to whom basically they are giving the authority, that is basically donee. Clear? Basically to whom the authority is to be given. Clear? So principal basically in favor of another person called the donee agent. Clear? To act on behalf of the former. Clear? Basically to act on behalf of the former, or basically to act on behalf of the donor basically as per the authority given in the document. Clear? Basically as per the authority basically given in the document. Clear? So following are the salient features of the power of attorney. Clear? So generally basically power of attorney, basically two types of power of attorney are generally granted. First one is the general or universal. Second one is the special or limited. Clear? So two types of power of attorney are basically generally granted. First one is the general or universal. Second one here, that is the special or limited. Clear? The second one, that is the special or limited. Yes, here basically donor. That is basically the person who is giving the authority. Clear? That is, it is a document basically executed by one person called the donor. Clear? That is basically who is giving the authority. Principal basically in favor of another person called the donee agent. Okay, so general power of attorney. Clear? General power of attorney basically it is issued for acting in more than one transaction. Clear? General power of attorney. Specific, that is basically for specific transaction. Clear? Here basically they are giving the general power of attorney. General power of attorney basically it is acting. It is issued. Clear? General power of attorney basically it is issued for acting in more than one transaction. Clear? And confers very extensive powers to the donor. Clear? Basically that is basically all powers are given to him. Clear? Whatever they can do, because now they have all the powers, clear, of operating the account. Clear? Now basically they have all the powers basically of operating the account. Clear? So special or limited. Clear? General. Next one is special or limited power of attorney. Basically it is issued for a specific purpose. Clear? Basically it is generally issued basically for a specific transaction, or we can say that basically for a specific purpose, or we can say that basically for a single transaction. Clear? Or often basically in most of the cases basically this is also issued basically for a single transaction. Clear? So basically you have to take care regarding all these things. Clear? You have to take care basically regarding all these things. next move to the second point. General power of attorney basically gives power to sign checks also, stop payment of check also, or to sign borrowal documents on behalf of the principal. Clear? On behalf of the actual person. Clear? General power of attorney basically it is gives power basically to sign checks, stop payment of checks, to sign borrowal documents on behalf of the principal. Clear? Third one. Basically, it is a stamped document. Clear? Power of attorney basically it is a stamped document. It is executed. Clear? Basically, and it is executed basically in the presence of a notary public. Here it is a stamped document basically, and it is executed basically in the presence of a notary public or magistrate of a court or government official. Clear? Authorized to do so. Clear? Basically authorized to do so. Clear? So it is a stamped document and it is executed basically in the presence of a notary public or magistrate of a court or government official authorized to do so. Clear? Next one, that is the principal basically can revoke the power of attorney. Clear? The principal basically can revoke the power of attorney at any time basically for future transactions. Clear? The principal basically the person basically who's giving the authority. Clear? The principal basically can revoke the power of attorney basically at any time basically for the future transactions. Clear? Power of attorney basically stands revoked. Clear? Basically on other sides. Clear? Obviously we can say that in other cases. Clear? Basically when it is revoked, clear, a power of attorney basically stands revoked basically by the death, insanity or insolvency. Clear? Basically of the principal. Clear? So power of attorney basically stands revoked by the death, insanity or insolvency. Clear? That is winding up or liquidation basically in the case of company. Clear? Or insolvency of the principal. Clear? Or insolvency of the principal. Clear? So these things. So please tell fast now. It is clear to all of you basically what is mandate, what is power of attorney, special power of attorney and general power of attorney. Please remember that basically it is a stamped document. Clear? It is a stamped document. Okay. Now move to the next. That is very, very important. Delegation of power. Clear? Basically delegation of power. Clear? Now let's discuss regarding that. Here one. Okay. Delegation of power. So if the holders of a joint account, clear? Basically if the holders of a joint account basically wants to empower a third party to operate the account. Clear? If the holders of a joint account basically wants to empower a third party to operate the joint account. Clear? So the authority basically should be signed. Clear? That basically power. Clear? The authority should be signed by all the account holders. Clear? If the holders of a joint account basically wants to empower a third party to operate the account, the authority basically should be signed by all the account holders. Clear? Any authority basically permitting the operation on a partnership account by a third party should be signed by all the partners. Clear? Basically should be signed by all the partners. Clear? Basically like basically if the account is joint holder, so basically it is signed basically to be all the partners. Clear? And in the case of the partnership form, basically it is to be signed by all the partners. Clear? Next one. In the case of the limited companies. Clear? Next one, that is basically in the case of a limited companies. Delegation of authority basically by a person duly authorized to open and operate on the company's account is possible only. Clear? In the case of the limited companies. Clear? Basically delegation of authority by a person duly authorized to open and operate on the company's account is possible only if that person has the specific authority to further delegate his powers. Clear? If that person basically has the specific authority to further delegate his powers basically to a third person. Clear? To a third person. Clear? Delegation of authority. Clear? Basically it depends upon the authority. Clear? Basically by a person duly authorized to open and operate on the company's account. Clear? Is possible only if that person basically has the specific authority. Clear? Basically that person has the specific power basically given to another person to further delegate his power basically to a third person. Like basically in the say, we can say that basically in the colleges. Clear? Just I will take the example in the colleges. Clear? So basically there are 2 or 3 authorities. Clear? Basically in the colleges basically there are 2 to 3 authorities. Basically who has the power. Clear? Basically who has the power to sign the document. Clear? Who has the power. Clear? So in that case basically they have given basically authority to the third person. Clear? Basically when one of the authority. Clear? Basically is not available there. Clear? Basically when one of the authority basically it is not available there. Clear? So some of these basic things basically you have to remember. Clear? Some of basic these things basically you have to remember. Okay. The power of attorney basically has to be fixed basically with the common seal of the company. Clear? Basically with the common seal of the company. Clear? Fiduciaries such as executors, administrators, and legal guardians. Clear? Basically cannot appoint agents. Clear? Basically cannot appoint agents, or basically they have not given power, such as executors, administrators, and legal guardians. Clear? A attorney basically cannot delegate his power. Clear? And attorney cannot delegate his power unless his power of attorney specifically provides basically for the power of substitution. Clear? Like we can say that basically we have discussed example like Ram gives power of attorney to the Hina. So here basically Hina further basically we cannot say that basically they can assign basically further one person. Clear? That is basically who can operate his account. Clear? Basically who can operate basically on the behalf. Clear? So attorney basically cannot delegate his powers unless his power of attorney basically specifically provides basically for the power of substitution. Clear? In case basically more than one person has been authorized. Clear? Basically in case basically where basically more than one person has to be authorized basically to operate the account. So in that case, basically clearly instruction basically about the operation of the account. Clear? Basically clearly instruction basically has to be given about the operation of the account. Clear? Basically whether to be operated singly or jointly must be obtained. Clear? Like we can say that basically they have given authority basically to the two persons. Clear? So in that case, they have to be get the permission. Clear? Basically either they have to operate the account single or jointly. And one thing basically I will tell you more clear, like basically for the checkbook issue, or basically for any this type of like for the updation of the name, please sign of both the account holder is to be must. Clear? Basically sign of both the account holder basically is to be must in that case. Clear? Just basically for operating the account, like basically we can say that basically for these financial like basically cash withdrawal or cash or NEFT RTGS. Clear? Basically in that case basically even if the account is joint holder, clear, one person basically will do the sign. Clear? Basically for all other things, clear, for the checkbook issue, for ATM apply, basically for number update, for nomination, clear, basically the sign of both the person is to be obtained. Clear? So in that case basically the signature of basically both the person is to be obtained. Clear? So please remember these things in these types of account. Clear? So this is basically the delegation of power. Clear? Basically this is basically the delegation of power. Next is garnish order. Clear? Garnish order. Clear? Basically garnish order is to be taken basically can be basically order from the court. Clear? Garnish order basically it is from the court. Clear? So this is the very important. So garnish order. Clear? So what is garnish order? Garnish order basically it is an order of the court obtained by a judgment creditor. Clear? Obtained by a judgment creditor basically attaching the funds basically belong to a judgment debtor. Clear? Like we can say that basically judgment creditor obtained by a judgment creditor attaching the funds. Clear? Like basically we can say that basically a person is not filing the returns properly. Clear? Basically is not showing the funds. Clear? And they have to give the more tax basically to the government, but they are not giving that. Clear? So basically in that case basically government. Clear? Basically we can say that basically, or in the case, clear, basically they are doing any fraud. Clear? So government basically court will issue an order. Clear? So garnish order basically it is an order of the court basically obtained by the judgment creditor attaching the funds basically belong to the judgment debtor. Clear? In the hands of his debtors, including a bank. Clear? Basically including a bank who's called garnishee. Clear? Basically including a bank basically who's called garnishee. Basically who has to perform the duty. Clear? Advising not to release the money basically unless directed by the court to do so. Clear? Basically unless directed by the court to do so. Clear? So basically when the bank basically will receive any court order, so basically they have to basically they have to hold the funds of the customer. Clear? Till the court basically has further to give any order. Clear? Basically what we have to do. Clear? So it is a process of law basically in favor of a judgment creditor basically for a debt due from the judgment debtor. Clear? That is basically from the bank customer upon a third party basically for attachment. Clear? So the order is issued. Clear? Under which act basically ICPC. Clear? Indian Civil Procedure Code. Clear? Basically the order basically it is issued basically under the Indian Civil Procedure Code order 21 rule 46 of that. Clear? So a garnish order basically served on a bank. Clear? A garnish order basically served on a bank basically attaches The credit balance basically in the account of the customer, clear, basically a garnish order basically served on a bank, clear, basically attaches the credit balance in the account of the customer name to the extent specified in the order, clear, to the extent specified in the order, clear. Like as per the court order, basically they have mentioned that, clear, basically there are 7 lakh mentioned basically available in the account of the customer, clear, and they say that basically you have to put hold basically 4 lakh, clear. So basically you have to put only on the 4 lakh, not on the 7 lakh, clear, and rest basically person can utilize the amount, clear, the rest amount basically person can utilize, clear. So that is basically as per the instructions, clear, basically as per the whatever the instruction basically given here in the order, basically they have to follow that, clear, basically they have to follow that. Okay. So basically, if no amount is mentioned, clear, if there is no amount is mentioned in that, so the order attaches basically all the sum owing and accruing to the customer basically as on date and time it is served and received by the bank, clear. If there is not any amount is specified, clear, basically if no amount is specified, the order attaches, clear, basically if no amount is specified, basically the order attaches all sums owing and accruing to the customer, clear, basically owing and accruing to the customer basically as on the date and time it is served, clear, and received by the banks. And checks presented basically after service of the garnish order basically should be returned with the remark that is refer to drawer, clear, that is refer to drawer, clear, basically if there is any check present by the customer and they are saying that basically the account having there is available balance in the account, clear, even after that basically you are not providing the payment, clear, that is basically refer to the drawer, clear, because on that garnish order is to be present, clear. So the service of the garnish order NISI is the primarily proceeding of the court, clear, basically it is the primarily main duty, clear, basically you have to follow that, clear. This is to be followed by subsequent proceedings of a court basically to make it absolute, basically when it is called garnishee absolute, clear. The order can only relate to the present balance in the account of the customer, clear, that is amount due and accruing due or payable to the customer basically at the time of the receipt of the order, clear, at the time of the receipt of the order, clear. So it is basically available or basically it is only applicable to that person, clear. So the order basically can only relate to the present balance basically in the account of the customer, clear, basically in the account of the customer, clear, that is the amount due and accruing due or payable to the customer basically at the time of the receipt of the order, clear, basically at the time of the receipt of the order. Basically in that thing basically I will tell you basically what is the important point basically you have to remember. Basically first of all basically what is the garnish order, basically it is the order basically of the court, clear, obtained by judgment creditor, clear, basically attaching the funds belonging to a judgment debtor, clear, attaching the funds basically belonging to a judgment debtor, clear. This is very important. And this account, this is very the service of the garnish order basically NISI is the primarily proceedings of the court, clear. And the amount basically can relate, the order basically can relate only to the present balance in the account of the customer, clear, only to the present balance in the account of the customer, that is amount due and accruing due or payable basically to the customer basically at the time of the receipt of the order, clear, at the time of the receipt of the order, clear. And can anyone tell basically here they are mentioning the words accruing? What is the meaning of accruing? ACCRUING, accruing. I think you have basically listened the word accruing interest, clear, accruing interest, clear. The interest is to be charged, clear, basically the interest is to be charged basically, but that has not been taken basically from the customer, clear. That is basically accruing interest, clear, like basically we can say that basically the person has the pay the installment on 2nd of October. Clear. So next installment basically it is on 2nd of November, clear. So in the meanwhile, on daily basis basically interest is to be charged, clear. So that is the interest is to be accrued here, clear. The interest is to be accrued here, clear. And the customer basically will pay on the 2nd of November, clear, as per the installment, clear. Basically that is basically okay, that is basically formed, clear, basically in the agreement, clear. So this is the basic, that is basically accruing, clear, that is. So the if no order is specified, clear, basically if there is not order is specified, so the order attaches all the sums owing and accruing basically to the customer, clear, owing and accruing basically to the customer as on the date and time basically it is served, clear, as on the date and time basically it is served and received by the bank, clear, and it is received by the bank, clear. So in this session basically we have to discuss up to this much point. If you have any query, any doubts, so please tell fast and I will upload already the slides, clear. In the next session basically we have to discuss some do's and don'ts under the garnish order, clear, that are also very important, clear. And here there is basically under that basically we will receive the order basically from the I2, that is income tax officer. We have to discuss also regarding that. Clear? That is also very, very important. Clear? So hope it is clear to all of you basically what we have discussed today. So thanks to all of you for joining this session.